I recall a fellow intentionally got his car onto the Frisco Highline Trail and drove his car on the Highline Trail and shot somebody out the window of his car. And then he went over on a different location and shot somebody else and then made his escape. The thing that made it memorable is while he had escaped, the police were searching for him and they were on the radio and other departments were keeping up with which direction he was going. And part of the time he's driving on the Highline Trail, which you can't do, but there was a deputy sheriff. And he determined that where this fellow was going, he would probably at some point come out at a certain location in a certain thing. So he drove to that location and waited. And darned if he wasn't right, found the guy, followed him the next time the guy stopped, and then arrested him. It was an amazing piece of police work, to be honest. And, once he arrested him, then all his car was full of evidence, and the rest is history.
Welcome to In Our Town, Conversations with Springfieldians Making a Difference. I'm your host, Tom Carlson, publisher of the Springfield Daily Citizen. If you'd like to comment on this episode, our email is inourtown@sgfcitizen.org. We'd love to hear from you. My guest today is the retiring Chief Judge for the Greene County Circuit Court. He leaves big shoes to fill. Before Mike Cordonnier took the bench in 2008, he was one of the top trial lawyers in southern Missouri. Then, after putting on the black robes, he has earned high marks from the local bar in his role as a jurist. I asked two of my lawyer friends about Judge Cordonnier. Kent Hyde with Hyde, Love, and Overby said, "I have tried cases in front of most judges in southern Missouri, and he's the best." And Steve Sneed with the Beatty Auto Firm said, "Mike was a fantastic trial lawyer and kept up on the law like few, if any, of his peers, me included. He feared no adversary and took on the best plaintiffs' lawyers in southwest Missouri and beyond. He was admired by virtually all of his peers." Steve went on to say the judge is frequently better prepared than the lawyers appearing before him. And the Missouri Supreme Court has recognized the judge's abilities by appointment to various administrative roles. However, in the interest of full disclosure, I should add that Sneed did tell me that the judge did marry up, as his wife Martha outdoes him on virtually every level. And he said I could quote him, Judge. Mike, welcome to In Our Town.
Thanks, Tom. I appreciate it, and I'll be sure to pass that along to my wife. She'll be most pleased to hear that, I'm sure.
Well, you donned the robes in 2008. This is 2023. About 15 years of service to your community. Why did you decide to retire?
It seems the right time. I think I'm old enough to retire, and I'm young enough to retire. I think maybe both. Certainly old enough. I've been doing this for 15 years, and I practiced law 25 years before that. But I still have some things I'd like to do, and I'd like to do them when I'm young enough to do them, including participate in dispute resolution with mediation and things like that I'd like to do after I retire.
Now, some judges who retire take on senior status and will still handle some cases from time to time. Is that in the cards for you?
I would probably do that. Any judge, I think, would be entitled to do that if the Supreme Court permits it. There are some cases that I might be appropriate for, complex litigation. I have a certification in that, and I've gone to other communities in the state and handled those types of cases, and I think I might still do those types of things, but mostly be dispute resolution, and then there's a process in Missouri for judges to appoint special masters in cases. The special master doesn't have to be a judge, but could be.
Well, again, you've served 15 years. What is it you're going to miss about your job?
I love the job, and I've enjoyed every minute of it, to be honest. I've always enjoyed being in a courtroom, and that's exciting, and it changes every day. The great thing about being a judge is you get to be in the courtroom every day, but you don't have to work, quite frankly, you don't have to work nearly as hard as the lawyers in preparation for a trial. Those lawyers work very, very hard, and they spend weeks as in the run-up to a big trial, working day and night. And I have lots of things to do as a judge, but I don't have to work day and night to get ready for any given trial.
You know, I was a lawyer, never a real litigator. My practice wasn't of that kind. But I heard lots of stories about trial lawyers doing just what you're talking about, preparing, working nights and weekends, and getting ready to go, and then the case gets postponed, and then you have to do it all over again. Is that a common complaint that you hear from lawyers?
It's not so common that cases get postponed. And let me correct you, Tom. You said you were a lawyer. I think you still are a lawyer.
Well, I don't know if I could fix a traffic ticket, but I guess I haven't given up my license yet. But
what does happen to cases, they don't get postponed so often if they're that significant kind of a case, but sometimes they get resolved by settlement, and particularly criminal cases or civil cases. As they get closer to trial, all the people, the parties, and the lawyers become more focused. And if there's some middle ground or a resolution to be had, that happens, and sometimes that happens on the eve of trial, quite frankly. And for the trial lawyers, it's quite disappointing because they have done all that work to get ready for trial. From their standpoint, the fun part or the enjoyable part is the trial, and then that doesn't happen. So that is disappointing.
my sense is, and correct me if I'm wrong, that happens more often than it did in the past. Fewer and fewer cases are getting tried. Would you agree with that?
I would agree that fewer and fewer cases are getting tried, yes. I mean, still we have a lot of cases get tried. It's always been that most cases get settled or dismissed or whatever happens to resolve them short of trial. I think trials have become very expensive, and lots of witnesses are usually called in a big case. I'm not talking a small case, but a significant case, and the witnesses are very expensive, and so the whole trial experience is very expensive, so it is not to be taken lightly, and fewer people are willing to risk that much financial input, among other things, in order to go to trial.
One of the points I'm trying to establish, if it's correct, you said you practiced law for 25 years before you went on the bench.
I did.
Ballpark, how many cases would you have tried?
Jury trials? Oh, not as many as you might think, probably 75.
And so you had a lot of courtroom experience.
I did.
And with fewer cases being tried nowadays, the pool to pick from to replace retiring judges probably doesn't have as many lawyers with that kind of trial experience.
That's exactly true. We're in the process now of selecting judges to replace retiring judges, and we have some excellent applicants. I mean, they are smart young men and women. They are wonderful people, honest as they could be, and they have tried a few cases, but not very many. You're exactly right. Their actual trial experience is not as many. I think they'll adapt and they'll learn and they'll do very, very well, but they don't come to the job with as much trial experience.
How will that affect, if much at all, the administration of justice?
I don't think it'll affect it. I think over time they will learn, a judge's job during a trial is quite a lot different than a lawyer's job. So those lawyers that are still able and do try those cases will still be doing their job. A judge's job is different. And these are new judges. Some of them have some trial experience, and we have some applicants that do have significant trial experience. And maybe the governor will select those applicants. But I think as they learn and as they learn the job, they'll adapt very well.
You're talking about the governor selecting these judges. Missouri is famous. I think it was the first state that developed a nonpartisan court plan. Whether it's first or not, it's different from the way judges are selected in many states. Could you tell our listeners how it works?
Missouri does have, in certain circuits, 6 circuits actually, only 6 circuits in the state of Missouri. There's 46 circuits in the state, so only 6 actually utilize the nonpartisan court plan, and it's referred to as the Missouri Plan. And it was adopted in Missouri for the first time in 1940, and it was adopted in Jackson County. And since that time, we have Jackson County, I think St. Louis County, St. Louis City, Clay County, Platte County, and Greene County.
The urban counties, more or less.
Exactly, and the reason for that, I think, is those are counties that are now big enough that it's pretty difficult, maybe impossible, for the average citizen to get to know their judge or their judges. So when they come to vote on a judge in the open election, like all the other counties have, and like Greene County actually had till 2008, they don't know the judge, and they don't have any basis upon which to make a decision, and there's really no way for a judge to campaign, because it would be unethical for a judge to put out literature about how they would or would not rule on any given case. So it's kind of a quandary. So those larger counties have adopted the nonpartisan plan. It also applies to the courts of appeal and to the Supreme Court.
Can it be improved?
There's always manners in which it could be approved. Currently the plan works such that in each of those circuits that have the nonpartisan plan, there's a committee of lawyers and then the chief judge of the appellate district, and then lay people that are appointed by the governor. And they interview all the applicants. They select a panel of 3. They send that panel to the governor, and then the governor interviews them, and he or she makes a selection. There's been thoughts that maybe the Senate should be involved, kind of like in the federal system where a senator proposes a name that the governor adopts that, and then the Senate has to approve them. We could do that. I mean, I think all in all, this plan works pretty well. I don't know that Missourians would be happy with it all across the state, because in small counties, people do get to know their judge.
Some cynics might say, well, you do the drill, but if it's a Democratic governor, it's more likely a Democrat is going to be a judge, and if it's Republican governor, after you go through, and I think typically don't they have 3 candidates for governor to pick from?
That's absolutely right, 3 candidates.
At the end of the day, does it help if you're of the same party as the guy who's going to make the appointment?
Probably essential, to be honest. The commission actually is charged with the responsibility of making sure these candidates are well qualified and well vetted. But when they turn over those 3 names to the governor, then it's political. And he can make his decision, or hers, but in this case it's he right now, based on whatever criteria he chooses, and there's no doubt that includes politics. But Missouri, changes its gubernatorial hands back and forth. The first 12 years I was a judge, we had a Democrat governor. Mm-hmm. So any replacement were Democrats. Now we have a Republican governor. So current replacements are either fairly neutral or Republican, but ultimately there's really no place for politics in judging, and it kind of dissolves away pretty fast.
And then just to kind of bring that to closure, once you get appointed, doesn't mean that you get to stay there for the rest of your life. There is a process if the public feels that a particular judge hasn't done a good job, that he or she can be replaced.
I'm a circuit judge. I served for 6 years, but when my time comes up under the nonpartisan plan, rather than stand for an open election where someone could run against me, I stand for a retention election. So my name's been on the ballot several times. And in the run-up to that, there's what's called a judicial performance evaluation. And that's a different committee of people. And they collect questionnaires from all the lawyers in the district. They collect questionnaires from, I don't know how many, but many, many jurors, if the judge is the type that has jury trials, from other areas. And then they do an evaluation report. And that's available to the public. So actually the public does have a judicial performance evaluation to consider before they decide on whether or not to retain a judge. Now you contrast that to an open election. If I were standing in an open election and no one chose to run against me, which, you and I have practiced law here for over 40 years, there hasn't been very many sitting judges have a contested election. If I didn't have a contested election, you couldn't dispossess me of the office. But with a retention, I have to then get 50% of the electorate.
Well, one thing I like about the nonpartisan court plan is, like anything, it can be improved. But you look at what has happened in some other states, that you may have a very contentious issue that may affect a large group of people, and it's the Supreme Court of the state that's going to make the call on that particular issue. Maybe it's public bargaining for employees or some sort of tort litigation that can move the needle in a big way. And then you have big campaigns with lots of money put into it, with lots of negative advertising by the special interest groups. And it's kind of assumed that if your guy or gal gets elected, when that issue comes before them, they're going to rule that way. At least we don't have that in Missouri.
We don't have that in all of our nonpartisan plans, and you hit the nail on the head, and you and I are both aware of tragic examples in other states. Maybe that's really occurred. So the beauty of a nonpartisan plan is the judge doesn't raise money, cannot raise money. So lawyers can't give money to judges in order to help them get elected in the nonpartisan system. And nor is there any need for a judge to raise money. And money and judging, they just don't mix well, and there's no reason for that. And so it works very well for us. For instance, let's just take the Supreme Court example you have raised. We've had nonpartisan plan in the Supreme Court in Missouri since I mentioned 1940. So those judges, for the office of Supreme Court, they've never raised a dime, and they don't campaign, and they don't do that sort of thing. And so when they have a very heavy-duty, contentious issue come before them, who gave money to their campaign does not weigh into the mix.
Well, yeah, people generally don't become a judge for the monetary remuneration. I think I can say, and I think people would agree with me, if you decided to stay in private practice, you could have made a lot more money.
It's true. I don't regret it one bit.
But
that's a true
brings
statement.
me on to my next question. So what's the attraction to people who want to serve in that role?
Attractions, probably several things. One is, as I mentioned, the opportunity to be in court and enjoy court more often without perhaps the rigors of getting the individual case ready for trial. Of course, you're relieved of some administrative things like searching for clients, making clients happy, billing clients, trying to collect from clients. Those are all things you've done in your career.
Absolutely.
And they're don't have to do that. But also, probably the most important thing is a sense of responsibility. I mean, I think we do make weighty decisions. We have lots of tools by which to do them. I mean, it's not a flip of the coin. We have a lot of background and methods by which we do that. But you feel like you're contributing to our community and to our system of justice, and I think those of us who do that have a sense of duty to the system of justice, and that's why we do it.
So following up with that, after what is it, almost 15 years in office, what are you most proud of?
I think one of the things I'm most proud of is the growth we've had in the Greene County Court in those 15 years. I've been here a little over 15 years, and when I started, we had 12 judicial officers. Like all circuits, we have circuit judges, associate circuit judges, and we have commissioners. So we had 12 total. We were the most underweighted circuit in the state. We needed, by judicial weighted workload, we needed over 7 more to keep up. It was amazing. So we went to work, and it's fairly political, went to work with our local politicians, our local senator, our local state representative. Bob Dixon, who's now our presiding commissioner, was a senator back then. He was very helpful. But now we have 18 judicial officers. And so things are so much better. We have the time to keep up with all the cases, and we are, absent a little setback with COVID, we meet time standards in all areas. 15 years ago, we could not meet the judicial time standards in any area.
So you've reduced the backlog in a big way.
In a big way. In fact, we remain current with these cases, and many of them, it's very important to be current, but we did not have the judicial resources 15 years ago to do that. And several of us who were very concerned went to work on that, and now we have 18. So while technically we still would need more than one additional judge, we believe we're fine, and we have enough judicial officers to do the job.
Typically, if you're a lawyer and representing the defendant, you're not too interested in a prompt trial. There may be exceptions, but you don't want to get to court. If you're the plaintiff, you want to get it settled and collect some money. And I'm sure it's all over the board, but if you file a run-of-the-mill lawsuit today and your lawyer is diligent, how long do you have to wait to try your case?
Okay, run-of-the-mill lawsuit. So I'm gonna define that for you. I'm gonna call that perhaps a car wreck case, a small car wreck, not a big one, or a premises liability case, something like that. Something would typically take 3 days to try. So we had trial setting conferences yesterday, and I set a lot of those cases in October, in November, and December of this year.
That's
Less
10
than a year.
months.
Yeah, 10 months. And I oftentimes could offer lawyers on those kind of cases trial settings quicker than they think they can have their case ready for trial.
Well, that's great.
Now, there's other kinds of cases. There's bigger cases that take a week or two. If they take 2 weeks, that's a different ballgame. Those cases are now being set well out into 2024. I have a case next month that's supposed to take 3.5 weeks. And that case has been set for probably 2 years, but those lawyers needed 2 years, or they wanted 2 years in order to get their case ready for trial. We often, like as I mentioned, can offer jury trial settings quicker than people really are able to get them ready.
You and I both being lawyers, a lot of things are understood that maybe the layperson might not understand. You and I have been talking thus far pretty much about civil litigation. There's a whole other aspect, which is the administration of justice. Tell us a little bit about how that's handled today as contrasted when you came on the bench.
Well, we have more judges now, and that's made all the difference. So right now in Greene County, we have 3 circuit judges assigned with primary criminal assignments. So they do all the felony cases. Associate divisions do the misdemeanors, and then they do preliminary hearings on felonies. I'll tell you what inhibits the ability to move criminal cases faster right now is, quite frankly, lack of lawyer resources, in particular public defenders. So if you were to say that half of the cases pending in our county are criminal, which is roughly accurate, and half of those cases those defendants are represented by the public defender, we're very dependent on the public defender. And they're a great resource. They do a fantastic job, but there's simply not enough public defenders. And they're not even full now. I mean, they have vacancies in our region of the public defender. They have vacancies right now and are not able to fill them.
I assume that's because the pay is low.
The pay is low, and it kind of depends on the economy. So right now, I mean, you and I have seen this ebb and flow throughout our careers. You know, sometimes the market's great for lawyers, and sometimes it's not.
It's true.
Right now, I think it's pretty good, and that doesn't help the public defenders when that's the case.
We'll be right back after this short break.
Hi, this is Rantzberger from the Springfield Daily Citizen. I'm here with my friend and colleague Corey Madison. And Corey, you and I made history here at the Daily Citizen.
That's right, Rance.
The first duo to have a double byline on a story.
For journalism people, or at least for this journalism person, that is the dorkiest, coolest thing. We each put in some work onto a story and get it in the best shape to put it out there into the world.
Teamwork makes good journalism, and our team certainly can't do our jobs without the help of subscribers like you, subscribers to the Springfield Daily Citizen. In Our Town listeners can get 15% off an annual subscription by going to sgfcitizen.org/town. That is 15% off an annual subscription at sgfcitizen.org/town.
And I'd like to point out that I think I was the first name on that double byline, the first one in history. You might have gotten the first billing on one that's followed.
That's all right. Second billing is still pretty good.
If you're representing a criminal defendant, you're usually not in a big hurry to go to trial. Maybe the longer you can string it out, maybe critical witnesses go away or their memories fade, and a lot of those guys that are probably going to end up in Jeff City would just soon be in the Greene County Jail as in the penitentiary in Jefferson City. Is that true, or would you disagree with that observation?
I don't disagree. I think that's the conventional wisdom that usually, and there are exceptions to every rule, but usually a criminal case does not get worse for a defendant over time. It may not get better. But as you said, sometimes witnesses do lose interest. Sometimes they move out of state. You know, lots of things can happen, but that really doesn't mitigate how we deal with it. I mean, we set the cases on a schedule. The lawyers don't really get to decide when they want their case to go to trial. We move them as quick as we can with a focus on more serious cases. You know, felony cases are classified by A, B, C, D, and E, and A and B cases are more serious cases. D and E are less serious, and there's a gradient in there. But we move them as quick as we can. We have some time standards which we try to follow. You know, within which we try to get those cases resolved.
In Greene County, there are more people living here, and we're living here 15 years ago, but maybe on a per capita basis. Do we have more crime than we used to?
I don't have a way to think about that. I think I have read publications that say we do. I don't think we have more criminal cases. Well, I don't think that. I know we do not have more criminal cases pending in court than we used to. Now, whether there's actually more crime occurring, I can't say that. You know, I have heard that, but we have more people living in Greene County, too, as you point out. So whether it's a per capita thing, I really don't know the answer to that.
One of the issues that come up from time to time in the criminal aspect of practicing law is bail. And there are some cities are saying that people, unless it's a very serious crime, should be released without bail. Others, of course, have different opinions. How are the rules as it relates to bonding out from jail if you're charged with a crime? Have they changed over the years?
They have changed. We're required to see people on bail applications quicker. We always have in Greene County. Our effort has been, to the extent we can meet it, and we generally do, is to see a person the day after they're arrested, because nobody should be in jail without having seen a judge and had their condition of being incarcerated evaluated. But the rules provide that we see them. We have a pretrial service group of people that collect information for us, that help us make better decisions. They tell us about that person's background, whether they're residents, whether they have past criminal behavior, whether they've been convicted in the past. We learn about whether they have failed to show up in court in the past, whether or not they committed additional crimes while they were on pretrial release in the past. And then we can fashion conditions of release, only one of which would include bail. Bail is typically money. And money is not by any means the only consideration. It may not even be the most important. So we have things available to us. We do want people to get out of jail if it's possible. I mean, if this person is presumed innocent, which they are, then the judge needs to be very careful to make sure we set a condition which causes them to come back to court when they're required to do so and protect society. And if we can do that, then they can be released. We have GPS available to us, both zone GPS and otherwise.
That's what we would call ankle bracelets.
Could be an ankle bracelet, right? And then we can set that to say, keep track of where a person is. We can also keep track of where they cannot be.
Oh, it's interesting. Okay.
So if we have a victim, for instance, that lives in a certain area, even though the defendant may not know that area, we can set a mile-wide curtain around that and tell that person you cannot go in that area to protect a victim, and they need to feel safe. I mean, this is important.
Well, who monitors that? Is there somebody at the sheriff's office with it?
Well, there's actually private companies that monitor that.
I see.
And,
okay.
And they do monitor that, and the defendant can pay for that, then they have to pay for it. If they cannot pay for it, then the county provides that. The county has some interest in getting people out of jail if possible, because it's very expensive to keep people in jail. We have alcohol monitors if that happens to be the issue. So all those conditions of bail have improved over the years, but we have so many more release conditions and release things available to us. The Greene County Pretrial Services can monitor people supervise people on those lesser crimes. They won't supervise people on violent crimes, but on lesser crimes, the people have to call in, confirm they still live in the area and that they're still trying to get a job or whatever it is that's being accomplished.
So if you were king and could change any of those rules, are there any rules that you think should be changed that would improve the criminal justice system?
Not along those lines, no. The things you're thinking of, or maybe you're thinking of, are things I've read about. I see on the news a lot where people are wholesale released from jail, people that are actually known to be violent criminals, and then they go out and commit other crimes. That's not happening in Missouri, certainly not happening in Greene County. The conditions of release are important, and we judges think those people we keep in jail should be in jail.
Just can't imagine what I've read happens in some cities where they just say if somebody wants to go in the Walgreens and load up a basket full of stuff and just walk out, nobody's going to stop them because the local prosecutor has decided not to prosecute those low-level crimes. And I have to think that results in greater lawlessness.
I can only imagine it would. That's not occurring in Greene County. I mean, we have a very skilled prosecutor, and I'm sure he evaluates hundreds of cases a month for sure, and chooses the ones that he would choose to prosecute. And he's pretty diligent about that sort of thing.
So here you are. You've got it figured out. You know what your job is, and lawyers are doing what you tell them to do. And it's clear sailing, and then COVID comes along. How did that change conducting the court business?
COVID was big in the court business. I recall when I first learned of it, I think we're probably March, could be February, I think we'll call it March of 2020. There was a meeting of business leaders, and I went because I thought I needed to hear what Health Director Clay Goddard at the time, what he had to say about that. And he pretty much said every business needs to close. And a lot of people were nodding their heads at that. They were going to close their businesses, and you recall most businesses did close.
Right.
Well, I went up to him afterwards, and I said, Mr. Goddard, just so you know, I'm the presiding judge, and we are not going to close. The courthouse cannot close. So I'd like to have your help in devising methods by which we can stay open because we are not going to close. There's nothing more important than access to justice.
Right.
And hospitals aren't going to close, and the courthouse is not going to close. And he did, and he put me in touch with his chief assistant, Katie Towns at the time, who's now the Greene County Health Director herself. Right. And we stayed open. We never closed. Not one day did the Greene County Courthouse ever close. Now, we modified things.
Now, wait a minute. I think I remember reading about you holding court over at Bass Pro.
We did. What we did was we had to modify things for spacing and all the things that came across you, and we followed the CDC health directives. You recall for a while it was 6-foot spacing.
Right.
Well, there's no way we can conduct court in the courthouse with people with 6-foot spacing. We can't.
You kind of had to make it up as you went along, didn't you?
Well, so we found large rooms. The Bass Pro Shop was one, the White River Conference Room, because, well, they were great to us. Nobody was renting those spaces for something else. So we started conducting trials at that location. We were the first in Greene County. We were the first county in the state to have a civil jury trial and the first county in the state to have a criminal jury trial. And we had quite a lot of cases over there in the next 2 years. Fortunately, at the time, we got to where we could bring everybody back into the courthouse. It was about the same time the White River Conference Room could be booked for every other kind of thing, weddings and everything else. And so they got very busy. Couldn't get in there now if we wanted to. They're so busy. but we don't need to now. So we're back in the courthouse. But we had a lot of trials over there, and quite frankly, the jurors loved it. It was a nice place to be, and the parking was great.
Well, did you have to take extra breaks for people to go over and check out the fishing rods?
You know, what they did on their breaks, I don't know. But, there was one time that was a lot of fun. It was in a winter case, and they brought out all the penguins. And
Oh, really?
Yeah, brought into the yard there right next to where the jurors were. We had a jury room, and so all the jurors got to go out and walk around with the penguins. It was kind of fun for them.
What is it, the Peabody Hotel in Memphis that's got the ducks that
Ducks.
they get in the elevator on the first floor and they come out on the top floor and just like little soldiers and hop in the pond? It's
Seen them do that every day, don't they?
Well, we've got a few minutes left. One of the things I want to ask you is tell us about maybe one of your most memorable trials and why it stuck in your mind.
I've had a lot of cases that are quite memorable. I recall a fellow intentionally got his car onto the Frisco Highline Trail and drove his car on the Highline Trail and shot somebody out the window of his car. And then he went over on a different location and shot somebody else and then made his escape. The thing that made it memorable is while he had escaped, the police were searching for him and they were on the radio and other departments were keeping up with which direction he was going. And part of the time he's driving on the Highline Trail, which you can't do. But there was a deputy sheriff, and he determined that where this fellow was going, he would probably at some point come out at a certain location in a certain thing. So he drove to that location and waited. And darned if he wasn't right, found the guy, followed him the next time the guy stopped, and then arrested him. It was an amazing piece of police work, to be honest. And, once he arrested him, then all his car was full of evidence, and the rest is history. But, I can remember other cases. There was a case subsequent to that here. There was a fellow in Springfield that drove recklessly around town and ultimately, tragically, blew through a stopped light and killed a woman. The woman was totally innocent, did absolutely nothing wrong, and left 2 little children and a husband. And this guy had concluded a drug transaction just prior to that.
He had, 50 pounds of meth in his car?
No, he had nothing in his car. This guy, he had completed a drug transaction, then the police tried to arrest him, and he sped off.
Okay.
They followed him for a bit and then broke off, but he kept speeding. It was an interesting case because it was called felony murder, and you're familiar with that. But a guy is charged with murder when he didn't have a specific intent to kill. This guy was driving recklessly, but his intent was to evade the police. The criminal intent comes from the previous felony, the drug transactions. He was then found guilty of murder. It was a tragic case, but it was an interesting case just from a legal standpoint. We don't have that very often. Murder is an intent crime. I mean, you have to prove someone intended to commit the crime. This is what's called referred intent. It's an offshoot. You had intent to commit a crime, but you caused a death in the mix.
I'm going to relate a courtroom story. I'm not going to say who the lawyer was. You may remember him. He's no longer with us. He was a hail fellow, well met. He had a build like Humpty Dumpty. And he tried a case in front of a jury. And it was his turn to get up and to address the jury for the closing argument. Took a big breath, and his pants fell down to his ankles. He picked them right back up, cinched them up, and kept going, I bet you have seen a lot of tales like that were not in the script.
I've seen some funny things. I've not seen something maybe quite that rich, but did have a case one time when a lawyer had his pants unzipped and the shirt tail was pulled out of his zipper. I mean, a big thought of whether he did it on purpose to distract people. I mean, no one really wanted to take him over in the corner and say, you need to kind of tidy this up a little bit, but he just kind of walked around that way.
As an ex-trial lawyer, I'm sure you've heard this story about Clarence Darrow, who took a safety pin, straightened it out, stuck it down a cigar, and then started smoking the cigar. And the ash got like 4 inches long, and nobody was paying any attention to the other lawyer who was making his argument because they were all waiting to see if that ash was going to fall,
Just a distraction. And basically, you want to distract the jury from thinking about what somebody else wants them to think about.
I'm given to telling stories. One time when I was on the city council, the State Highway Commission came down to Springfield, and I was to make a talk in front of them. Well, they put me in front of the Shark Tank at Bass Pro, and the shark just keeps moving back and forth in the big tank. And it was so distracting because everybody's heads in the audience just moved with the shark. You know, you could never get anybody's attention like that. I want to ask you, before we close, what advice would you give to a young person who's considering entering the legal profession?
It is a fantastic profession. I've enjoyed it very much. It is certainly a profession where you can do any number of things. I mean, you can be a courtroom lawyer. I would suggest that most lawyers don't go to court. That's not part of their practice. They do business work or they do real estate work. You've done both of those in your career. They do a variety of things. So it's not all about courtroom work, but if that's something you enjoy, then that's available. I would give them the advice that they need to find which area they have a passion for and pursue that. One thing that has occurred in my career is that lawyers are more specialized than they used to be. Early in my career, probably early in your career, lawyers did some of everything.
Right.
They don't do that so much anymore. Lawyers specialize in bankruptcy or real estate or corporate law or criminal defense or tort litigation or one of many other things. But they do specialize, and that's different. And it's probably ultimately going to be necessary for a young lawyer to be successful to ultimately specialize a bit. But they should plan on, you know, it doesn't come easy. You'll have to work hard, but it's rewarding, and they'll have to at some point have a work-life balance they'll have to deal with.
Well, Judge, I think we're drawing to a close here. I want to thank you for your years of service to our community. And in a time when not all lawyers are held in high esteem, you have led by example. Your shoes won't be easily filled. Finally, I want to thank you for being this week's guest on In Our Town.
Tom, I appreciate it very much. Thank you.
You're welcome. That's it for this week, folks. Many thanks for listening. If you'd like to listen to other episodes, you can visit the Springfield Daily Citizen website at sgfcitizen.org/NRTown or subscribe wherever you get your podcasts.